We will now go to Ms. Swanson in London, please, for your 5-minute opening statement.
I come before you as the voice of 1 million Canadians. We are Canadians. Many have been Canadian citizens for life or for decades. We chose Canada. We expect Canada to now choose us and our rights over foreign bully demands. Why do our most heinous criminals have more charter rights than I do? Asked the Nova Scotia police officer of 33 years. He was born in Maine almost 6 decades ago when his New Brunswick mother was sent there to give birth. A Quebec woman who has been a Canadian citizen since birth says her ancestor, who came to Canada in 1682, must be turning over in his grave at FATCA. A widowed grandma in Vancouver was told by U.S. consulate when she became a Canadian citizen in 1972 she was permanently and irrevocably relinquishing American citizenship. She insists my financial records are definitely none of the business of the IRS. An Ontario First Nations husband and father is horrified his Canadian government will help United States seize his family's private financial records because his wife was born there. An Alberta woman reports her mother, who upheld Canadian laws for many years as a justice of the peace, is now medically and physically too frail to deal with FATCA stresses. They and 1 million other Canadians were betrayed by the FATCA Intergovernmental Agreement. We were offended and insulted to hear Minister of State for Finance call us American citizens abiding in Canada in the House of Commons. If Canada mandated financial institutions to seek Canadians born in China, India, Iran, or Eritrea for CRA to transmit private financial information to those nations, there would be outrage. Canadians born in the United States should have the same rights as all other Canadians. Canada should strongly defend those rights and not sacrifice them to a foreign country. 2 prominent Canadians described FATCA well. In 2011, and many times after that, Finance Minister, the late Jim Flaherty, said, FATCA has far-reaching extraterritorial implications. It would turn Canadian banks into extensions of the IRS and would raise significant privacy concerns for Canadians. Terry Campbell, president of Canadian Bankers Association in 2012, called FATCA the poster child for the problem of extraterritoriality. It threatens to erode Canadian sovereignty. Those statements hold true now. Under threat of economic sanctions and penalties, Canada surrendered its sovereignty to foreign power with the IGA. Canadians affected by FATCA were stunned last week when a member of this committee said, Congress has spoken. Canadians expect Parliament to speak for Canada. Canadians expect Parliament to uphold Canada's laws, rights, and Constitution. Anything less is an affront and betrayal to Canada and to Canadians. FATCA is complex. I give you a simple solution. I urge you to adopt an amendment to the Implementation Act. Notwithstanding any other provision of this Act or the agreement, for all purposes related to the implementation of this Act and the agreement, U.S. person and specified U.S. person shall not include any person who is a Canadian citizen or legal permanent resident who is ordinarily resident in Canada. I implore you, do the right thing. Stand up for Canada and for all Canadians.
Very much, Ms. Swanson. We will now go to Mr.
For Ms. Swanson, and I want to thank you for your very spirited presentation today, Ms. Swanson. I'd like to first ask you, again on the issue of privacy, Government officials, the Minister of Finance, Conservative MPs tell us privacy concerns have been resolved through the intergovernmental agreement because information is going to be sent to the United States from our CRA, not from the banks themselves. Why isn't that acceptable to you and to your group?
Quite frankly, involving the CRA does not resolve our privacy concerns. What the IGA does and what the Implementation Act does is it's actually unprecedented, as I understand it, in Canadian law, in that it, for the first time, singles out one group of Canadian citizens. It prevails over all other Canadian laws for the benefit of a foreign nation. And the IGA may legally protect the banks under privacy laws, but it does not in any way address privacy concerns. Instead, sending the information to the CRA places this in a double jeopardy situation. So first, our private financial information, which is going to be much more comprehensive than any other Canadians have to submit. It includes our total assets, our account balances, all our transactions, our account numbers, other personal identifying information, and any other information the CRA demands, the IRS demands. So I think most Canadians would be outraged if that information was going to CRA. Okay. On top of that, the Privacy Commissioner has indicated that the CRA has privacy issues. There are identity theft issues.
Thank you.
Thank you very much.
Thank you.
But I really appreciate your presentation.
Ms. Swanson, when you became a Canadian citizen, did the U.S. consulate make it clear to you that you were still considered a U.S. person for tax purposes?
No, in fact, the U.S. consulate did exactly the opposite. My experience was the same as the grandma in Vancouver that I mentioned. I called the U.S. consulate in 1973, so that was 41 years ago, and they told me clearly, firmly, and directly I was permanently and irrevocably relinquishing U.S. citizenship. I had no idea the Americans still considered me to be a U.S. citizen or a U.S. person until 2011, when a friend sent me an article that had appeared in the Financial Post that indicated that without my knowledge and consent, the U.S. Supreme Court had reinstated my citizenship in 1986. And my Canadian, if I could just say as well, my Canadian citizenship certificate says, Lynn Swanson is a Canadian citizen and as such is entitled to all of the rights and privileges and bears all of the responsibilities and obligations and duties of a Canadian citizen. For 4 decades, I have met my responsibilities and obligations to Canada. I now expect Canada to meet my requirements to uphold my rights in Canada and those of all other Canadians.
Okay, thank you. We'll go to Mr. Adler, please.
Why don't you go first?
Or sorry, Mr. Allen.
Okay. We're going to split.
All right. Okay. Thank you very much, Mr. Chair. And I just want to make one clarification comment to Ms. Swanson. I, in fact, am the one who made the statement on the U.S. Congress has spoken. I freely admit that. And when I said that in the context, when we were in Washington, we were pressing the Treasury Department on this whole FATCA thing. And the response we got back from the U.S. Treasury person was, well, I'm sorry, Mr. Allen, but Congress has spoken. So we were somewhat mortified by her attitude as well. So I just want to say that that was the context of that comment. So
could I just respond to that briefly and say what we would like? Okay, what we would like is we would like Finance Canada to go back to U.S. Treasury and say Parliament has spoken, and Parliament is going to stand up for Canadians, Canadian citizens and Canadian residents.
And which is why we signed the IGA.